Thank you for the introduction, and thank you, Professor Matthew, for having me. The topic of my presentation is the proposal of India and South Africa for a TRIPS waiver, and I will be discussing the context to the waiver proposal and an overview of the contents and scope of the waiver proposal. First of all, the COVID crisis is a global problem, and global problems, they require global solutions. Why it is a global problem? Because it has impacted each and every one across the globe in one way or another, no matter where they live, and it has already caused 5.2 million deaths worldwide. And although it impacted the countries equally, but their resources to tackle the pandemic, they were not equal. There were gross inequalities in economic resources and medical resources. And there were issues of vaccine nationalism, nationalistic and unilateral approaches in response to COVID-19 that further added to the woes and consequences for the global population. Poor nations, they were left to rely on charitable donations and optional goodwill of the big corporations because of the pre-purchase agreements by high-income countries who use their economic might to engage into advanced purchase agreements with the potential developers of COVID vaccines. And currently, less resourceful countries are scrambling for access to vaccine doses. I will provide some further background to the TRIPS waiver proposal. Barriers posed by intellectual property. Intellectual property poses barriers to access to COVID-19 vaccines and other COVID-related technologies. It's beyond the scope of this presentation to discuss all forms of intellectual property. I will just rely on one example of one form of IP, that is patent law. Patents are private exclusive rights. Patent protection conflicts with reverse engineering and manufacturing of patented health technologies because the patentee, patent holder, has exclusive rights over making, selling, offering for sale, importing. They control all these activities, and if any generic manufacturer, if any company is engaging in those activities without their consent, without their approval, they will have to face the consequences in terms of litigation. Patents enable patent corporations to dominate the market and derive maximum profits during the 20 years term of the patent. So the patents related to COVID technologies, they have a long life ahead of them, a 20 years period, so long waiting times. Context to the waiver proposal. When very early on from the start of the pandemic, there were benevolent statements from political leadership, from the heads of multilateral institutions, that no one is safe unless everyone is safe. And there were calls for people's vaccine, global public goods, and vaccines should be considered as global public goods or global health commons. There were all those sorts of statements coming from the political leadership and from the heads of organizations like Secretary General United Nations and from the DG, WHO. And in April 2020, the United Nations General Assembly passed 2 resolutions, and they had this similar message that they call for rapid scaling of manufacturing of COVID-related technologies and timely and equitable access to vaccines and other technologies. And in May 2020, the World Health Assembly's COVID response resolution, it again said the similar things like universal, timely, and equitable access to vaccines and fair distribution of vaccines, and response to COVID-19 should be considered as global public good. So all this virtue signaling going on right from the start of the pandemic. But it was not followed by concrete policy actions by the political leadership. And there was clear, IP is a clear barrier to the themes like vaccines as public goods, vaccines as public as common, global health commons, people's vaccines, because of the barriers posed by IP. But there was no clear policy action or policy response to tackle with the IP barriers. There were some initiatives. They were started like the COVID access, technology access pool of the WHO, CTAP, but not a single patentee corporation. They signed up to that initiative. They didn't join, not even a single corporation joined that CTAP initiative by the WHO as requested by the government of Costa Rica. And from WTO, there were no legal institutional response. Because WTO is mainly dealing with the IP issues. In this context, on October 2, 2020, India and South Africa presented a waiver proposal to the WTO TRIPS Council. What was the scope of the waiver? India and South Africa sought waiver from the implementation, application, and enforcement of the IP rights of products and their underlying technologies for prevention, containment, or treatment of COVID-19 until herd immunity is achieved. The waiver proposal was applying to all WTO member states. It was not confined to only India and South Africa. If it is adopted, it will apply to all WTO member states. And it would cover all medical products and equipment required for preventing the spread of COVID-19. Forms of IP covered by the waiver. The waiver covered the waiver would encompass Section 1 of the TRIPS agreement, that is related to copyright and related rights. Section 4 related to industrial designs. Section 5 patents, and Section 7 protection of undisclosed information, the manufacturing know-how, trade secrets, and trademarks and plant variety protection. There were obvious omissions from this list of forms of IP covered by this proposal. What was the duration of the waiver? The proposal left the duration open-ended unless the herd immunity is achieved globally. And it will be applicable for X years. They use the language X years, so they leave it open-ended. There was criticism about the scope of the waiver because it covered, of the original waiver, it covered all technologies, all medical products. There was no exhaustive list of the technologies covered by the waiver. So, in response to those concerns, on May 21, 2021, India and South Africa, along with 64 co-sponsors, submitted a revised proposal. What was the scope of the revised waiver proposal? The range of products and technologies narrowed down to health products and technologies, including diagnostics, therapeutics, vaccines, medical devices, personal protective equipment, their materials or components, and their methods and means of manufacture for the prevention, treatment, or containment of COVID-19. Still, a lot is covered, and there are calls to further narrow down to only COVID vaccines, but it is yet to be seen whether it will be further revised. The current proposal covers this much of technologies. The revised duration of the waiver. Previously, it was open-ended. Now, they provided a clear time frame. The duration of the waiver was set to at least 3 years from the date of the decision. This time frame is, however, subject to annual review of the waiver. What is current status of the waiver proposal at the WTO? In December 2020, within 90 days time frame, the WTO TRIPS Council is required to discuss the waiver proposal. within 90 days and then report to the WTO General Council. They did it. They reported to the TRIPS General Council in December 2022 and 2020 within the 90 days time frame. But the General Council advised them to have further discussion on the proposal. So it's still in the TRIPS Council. The waiver proposal is supported by more than 100 countries and more than 300 civil society organizations. The support for the waiver has increased over time. In May 2021, USA, Spain, and New Zealand, they publicly announced their support for the waiver. In June 2021, France declared its support for the waiver, and in September 2021, Australia joined the countries that are supporting the waiver. Currently, the TRIPS Council is deliberating the 2021 revised version of the waiver proposal, but the negotiations on the waiver proposal have been very slow. And I will come to this point that the negotiation process at WTO is normally slow. It's nothing new. What are future prospects? If a consensus is reached, the waiver would be formally adopted by the WTO General Council if consensus is reached. If a consensus is not reached, the waiver can still be adopted by a 3/4 majority if the proponents call for a vote in the WTO General Council. So we have two possibilities, but for both of these possibilities, there is achieving the 3/4 majority is still it requires a lot of negotiation and consensus building. Delays are anticipated because previously, this is not the first time there's a request for a TRIPS waiver. There was a waiver achieved in August 2003. And this is the timeline of the previous waiver. The TRIPS agreement was signed in April 1994, and there were public health issues that needed to be addressed. And TRIPS agreement included public health flexibilities, but the high-income countries, they were reluctant to allow low-income countries to make use of those flexibilities. What happened in 2000 when South Africa tried to amend its Medicines Control Act to allow parallel importation of drugs, 39 multinational corporations collectively sued the South African government and the High Court of South Africa. And those 39, that group of 39 multinational corporations was supported by high-income countries like the US, because these companies are based in these high-income countries and they enjoy the political support. And in the wake of that litigation, the low-income countries, they demanded more clarity on the use of those public health flexibilities. And Doha Declaration of 2001, it was achieved in November 2001, was a result of that, those calls for that more clarity on public health flexibilities. But there was one outstanding issue that couldn't be addressed at Doha, because the TRIPS agreement allows compulsory licensing of patents, but the original Article 31, it puts a constraint, it puts a limitation that the products manufactured under Article 31 by use of compulsory licensing under Article 31 can only be used within the territorial jurisdiction of the country that is issuing the compulsory license. They cannot be exported. No other country can import them. So it was a major hurdle for those countries who lack manufacturing capacity. Even if compulsory license is issued, they can't get any benefit from that because they can't import the products manufactured under the use of compulsory license. So that outstanding issue was still there. 2 years further negotiation, and finally in 2003, the TRIPS Council waiver decision in 2003 was achieved. To make it part of the TRIPS agreement, to adopt the amendment, 3/4 majority was required, and that 3/4 majority was achieved in January 2017. So it took 22 years to address a very simple question, to address a very simple issue of the effect of the compulsory licensing, to enhance the impact of the compulsory licensing. Benefits of the proposed waiver: it will have health benefits, economic benefits, and political benefits. I will come to each of them. What are the health benefits? COVID-related health technologies are already patented. For instance, the mRNA technology used by Pfizer and Moderna, it is protected under 59 patents, and all of those patents have a patent life of more than 10 years ahead of them, so they're not expiring soon. Reliance on just a few brand name corporations will result in preventable suffering and loss of human lives. Vaccine-resistant variants may keep emerging from resource-poor regions, as it is happening. The waiver will provide legal certainty to accelerate the production and supply. So some of those sufferings and human lives, many of those sufferings and human lives can be prevented if we can timely achieve herd immunity at a global level by increasing the production and supply. And for that, we have to overcome the IP barrier, and waiver is aimed at overcoming those IP barriers. Economic benefits: COVID-19 has caused economic harms of tens of trillions of US dollars. According to International Chamber of Commerce, future economic losses may exceed US $9 trillion. According to United Nations Development Program, there will be income losses of US $220 billion only in low and middle income countries. And according to United Nations University World Institute for Development Economics Research, an additional 400 to 580 million people will be facing extreme poverty as a result of COVID. So as soon as we are able to control the pandemic, we will be able to mitigate some of those losses or prevent some of those economic losses. Political benefits: the COVID-19 crisis challenged multilateralism and its institutions. International institutions failed to stop vaccine nationalism. The current pandemic tests the ability of the WTO system to respond to a global humanitarian crisis. The very legitimacy of the multilateral institutions like United Nations and the World Trade Organization is at stake, because there have been a lot of virtue signaling, nice statements. No one is safe until everyone is safe. People's vaccines, public vaccines as public goods. There have been a lot of nice statements, but they haven't been followed by concrete policy actions. So if these institutions that fail to deal with this humanitarian crisis, their very legitimacy is at stake. It is critical to build political commitments that limit nationalistic or unilateral approaches. To support the waiver is in the long-term interest of many players who back globalization, trade liberalization, and free market economy. Key objections are the opposing view. There are many objections, but I will stick to 4 of them. Waiver is needless because the existing flexibilities in the TRIPS agreement are already sufficient. Waiver would be detrimental to innovation. Waiver would cause strain on raw materials. Waiver would cause safety concerns. I will touch one by one. Existing flexibility: compulsory licensing is the most prominent existing flexibility relevant to COVID technologies. The negotiation of a compulsory license is complex, time-consuming, and often inefficient. Compulsory licenses fail to provide a global solution as they are granted on a country-by-country, case-by-case, and product-by-product basis. So if mRNA technology is covered under 69 patents, you have to go for multiple applications for compulsory licensing, and each compulsory license will be limited to the territorial jurisdiction of the country issuing the compulsory license, because patent law is territorial in nature. There's no universal patent law. Each country has its own patent laws, and each country is issuing patents within their under their national patent laws. So there will be country by country compulsory licensing, product by product, and it's really complex and complicated to have any global impact. And compulsory licensing protection covers only patents. There are other forms of intellectual property that can be barrier to access, but they are not covered under compulsory licenses. So it is limited in scope and impact. Many low-income countries lack an appropriate legal framework as well as technical and institutional capacity to deal with the compulsory licensing of patents. Export-oriented compulsory licensing has failed. It was, since 2003, it has been used only once. In the context of COVID, there has been an attempt to use this option since Feb 2021, but no progress made so far. Not even, it hasn't been initiated even in more than 9 months. Waiver would be detrimental to innovation. The big pharma argues that if there is a waiver of intellectual property, they lose incentive to further innovate because the profits will be compromised. They will not be able to recoup their investments into R&D. But these arguments don't sustain in the COVID context because their financial risk was reduced because of pre-purchase agreements, and the COVID market for vaccines is the entire world, and their demand is going to be long term. So even after sharing the technology, they have sufficient opportunities to recoup their R&D and to make handsome profits. Waiver would cause strain on raw materials. Pfizer CEO raised a concern that waiver would lead to worldwide race for raw materials. On the other hand, the patentee corporations, they argue and they claim that they have the capacity to provide vaccines for the entire world, for the global population. So if they are able to provide vaccines for the global population, it means the raw materials, access to raw materials is not a concern. They are not citing it as a concern. So the real consideration for them is to keep their control, to retain their monopoly control on production and supply. Waiver would cause safety concerns. They think that there will be counterfeit products if there is a waiver. If the big corporations lose control on production, there will be fake and counterfeit substandard products in the market. But these claims are not backed by empirical evidence. Before 1995, there was no patent protection on pharmaceuticals, and the generic manufacturers, they were making the pharmaceutical products. And still, India is one of the biggest manufacturers of generic manufacturers, and Indian generic manufacturers are exported to even USA, EU, and the people have trust in the generic manufacturers, and they are safe and efficacious. So these concerns are just speculative and hypothetical. They are not backed by factual empirical evidence. The request for a waiver is a reasonable and legitimate demand. The objections to the waiver proposal are superficial and speculative. For developing countries, access to COVID-19 vaccines and treatments through charitable donations and diplomatic channels is not a viable option. The waiver is important not only for poorer countries, but also for the legitimacy of the multilateral WTO system in terms of managing trade as well as humanitarian concerns. Thank you so much.